My name is Sheldon Pivnick. I'm Chief of the Traffic, Signals, and Signs Division of Metropolitan-Dade County in Miami, Florida. I'm also a practicing attorney in the city of Miami, and I want to talk to you about a problem that has become most important to us in the transportation field, and that is the area of liability as it applies to construction work zones. A recent survey conducted by the Trans-Safety Reporter, which is a newsletter for engineers and attorneys dealing with tort liability in the field of transportation, has shown that 50% of the cities responding to the survey feel that there will be a 50% increase in liability cases. And amongst the highest in the area is what happens in a construction work zone. And if you're familiar with some of the principles of tort liability and risk management, perhaps you can nip the problem right at the very beginning. For while you cannot keep yourself from avoiding costly lawsuits, you can minimize your risk and reduce your liability potential of your agencies. And that's what I want to talk about today. What I'm going to talk about in particular is a subject called a tort. What is a tort? A tort is nothing more than a private or civil wrong or injury. It is something aside from contract. It is not a criminal act because we did not intend to injure someone. It is an act that has occurred because we have done something wrong or we have not done something that we are supposed to do. And interestingly enough, in every tort, there are three basic elements involved. There must be a legal duty by the defendant to the plaintiff. The defendant, of course, is the party that is alleged to have caused the injury, while the plaintiff is considered the injured party. Not only must there be a duty, but there must be a breach of that duty. Breach can be an overt act where you have gone out and you have improperly maintained a traffic control device, improperly signed a control work zone. Or it could be a non-act, your failure to respond within a reasonable period of time. There must be that third element. Someone must have suffered damage as a proximate result. And I'll get into that in a little more depth in a few minutes. But you must understand in every tort action there are these three basic elements that must be present. The most common area in tort that we're going to be interested in, the one that affects us as traffic and transportation people, is the area of negligence. And the key in negligence is that we have failed to use reasonable care in our action. All the courts require us to do is to use reasonable care. They don't require us to be an absolute ensurer of safety, but we must respond reasonably. In every negligence suit, the attorney must prove the five basic elements. He must prove it not by beyond a reasonable doubt as we find in a criminal action, but he must prove it by the preponderance of evidence. To explain what I mean by the legal jargon, if you will, going into court, the scales of justice remain in a balanced position. All the attorney has to do is tilt it a little in his favor to be successful in the suit. What are these five elements? Well, as we said, the first of these elements is duty. There must be a duty to the injured party. This is probably the easiest one for the attorney to prove on behalf of his injured client. Why? Because if you look at the preamble that has created departments of transportation, highway departments, road departments, even municipal transportation agencies, county transportation agencies, they all have the same fundamental beginning. It is the duty of this agency to maintain the roads in a reasonably safe condition. So under these circumstances, the attorney normally has no problems proving there was a duty to the injured party. There must be a breach of that duty. Someone must have been doing something they shouldn't have been doing, or doing something they should have been in the wrong way. The overt breach, that is the responding improperly, using wrong material, not fixing it correctly, or the non-overt breach, or the failure to respond, the failure to maintain, the failure to arrive in a reasonable period of time, the failure to review of what's going out in your construction work zone. All of these constitute a breach. There must be a proximate cause. There are generally two causes in every lawsuit. The actual cause, which is the actual cause of the accident. For example, if you look at a signalized intersection, the signal is not operating properly. The drivers may perceive that it's not operating properly, but they both enter the intersection without reasonable care and are involved in an accident. The actual cause of that accident is the failure of the drivers to use care. But the court is more interested in the proximate cause, because it is the proximate cause that leads back to the person with the deepest pockets, the government agency, the state agency, the municipal agency. They have the deepest pockets. They have the most money, and they have the ability to pay promptly. And to look at the accident that we just discussed, suppose the real cause of that accident was the failure of the agency to respond promptly to repair that traffic signal. That is the proximate cause. And that leads the lawsuit back from the individuals involved in the accident who had the actual cause back to the individual who has been charged with the legal underlying cause or the proximate cause. So the attorney is now going to try to prove proximate cause. He is now going to try to prove that his client did not contribute to his own or her own injuries. Why? Because some states are called contributory negligence states. They say that if the injured party contributed to their own injury, they may not recover a penny. Other states say if the driver has contributed to their own injury, they are going to get a reduced amount of award. That's called a comparative negligence state. And in a comparative negligence state, the jury decides the degree of responsibility of the two parties. For example, they may say that the injured party was only 30% negligent, while the defendant, the government agency, was 70% negligent. They would reduce the award given to the injured party by 30%. So the attorney is going to try to prove that his client or her client did not contribute to their own injuries or did so in a reduced amount. There must be damages. And damages involve everything from property injury to personal injury. They can be a physical injury, a mental injury, and it's even grown further than that. At one time, you could only collect for a physical injury. Then the courts expanded it even more, saying that you can collect if you suffered a mental injury as a result of the impact of a collision, for example. They went a step further. They said if you were in the zone of danger, even though you may not have been involved in the impact, but as long as you were in the zone of danger and you became so concerned about being hurt that you suffered some sort of a mental duress, you could collect for your mental injuries. Well, they've expanded that even more. Now a witness to an accident, as long as they bear a relationship to the injured parties and they suffer some sort of mental anguish, can also collect for their injuries. And the classic example of that is the mother who witnesses her child being struck in a vehicle accident. The mother suffers a mental breakdown, and the family lawsuits that result out of that one accident with the child include the child's injuries and the child's own action to recover for their injuries, the mother's injuries, mental injuries for viewing the accident, and the husband who can collect for the loss of the child's companionship and the loss of his wife's services. So out of one accident, you can have 4 separate suits, which shows you what can happen if you're not careful at the very beginning. At one time, there was a certain amount of immunity that government agencies had. It was primarily because we were what was known as a common law country. We had our beginnings from English law. English law developed as far back as 1066 when William the Conqueror was successful in the Battle of Hastings. He established what were called the Common People's Courts. And under the common laws, the king could do no wrong. And the English courts felt that if the king could do no wrong, the king's governments could do no wrong. It came to the United States, and it felt that government agencies operating as the sovereign of that area could do no wrong, and therefore they were immune from lawsuits. Unfortunately, that did not last very long. As a result of that, the attorneys were in a position to try to overcome the immunities, go into court, and prove the 5 areas of the negligence suit that I have just briefly discussed. That there had to be reasonable care, that there was a breach of the duty, that the injuries resulted from a proximate cause of the breach, that the plaintiff, the injured party, was not guilty of contributory negligence, and that the plaintiff suffered the injuries. How then did you go beyond these immunities that kept the attorneys out of court from the very beginning? The immunities, briefly, were 3 separate immunities because they all had the same fundamental beginnings about the same time. There was charitable immunity, family immunity, and the big one, government or sovereign immunity. The family immunity said that one family member could not sue another family member because the idea was to keep the family nuclear. They did not want one family member involved in a court and breaking up the nuclear family. The charitable immunity, on the other hand, they did good. The charities supplied nursing homes, old age assistance, food programs, orphanages, and the courts felt that if a charity was to be concerned with their own liability, they wouldn't want to do it. And therefore, good was better than evil, and it was better to forget the smaller evils. And then the government provided these services, and the government could do no wrong because William the Conqueror said so in 1066. Well, that has all been chipped away. Charities are now responsible for their own tortious acts. A recent case in Boulder, Colorado, where a young man sued his mother and father for wrongful bringing up, charging them with the fact that they raised him improperly, that he could not hold a job, he could not maintain social contacts, and he wanted $650,000 from his parents to make up for that. All of these were the chipping away of the immunities. Well, the same thing happened in our area of government immunities. The first thing occurred in 1842 in New York State, when the courts decided that governments operated in 2 distinct areas, a proprietary area and a governmental area. The proprietary area was an area where the government performed the same function as a private business: garbage collection, sewage collection, construction. While the governmental area of the government were the decision-making, how to tax, police protection, fire protection, the peculiarly governmental functions. The court said that if it was a proprietary function, the governments would be responsible for their acts. If it was a governmental function, they would still have the sovereign immunity. The government could do no wrong in a governmental function. The courts went a step further later on and brought us to where we are today. They said every government function is 2 distinct functions: a discretionary or decision-making function and a ministerial or an order-carrying out function. If it is discretionary, there is no liability. It is immune. Discretionary is design in our area, the decision on how to apply resources, the decision on how to spend money. The ministerial is the one that we are really involved in. Ministerial is carrying out orders. It is the construction function. It is the maintenance function. It is the the function where we deal with the utilities, the contractors working on the roadway. Construction work zones fall in the ministerial function. Therefore, we face total and complete liability within the ministerial function. Also, we have to worry about our own personal liability, the liability of private parties. If you're working for a consulting firm or you're working for a contractor, you are just as liable as any individual involved in the accident. If you're working for a contractor and you do wrong, you can be sued personally. If you're working for a vendor or a supplier and you do wrong, you can be sued personally. Government agencies are different. A lot depends on the state where you live. Some states say that the injured party must make a choice. They must either sue the government agency or they must either sue the individual. They cannot sue both. Naturally, they will take the person with the deepest pockets, the government agency. Other states say you may only sue the government agency. You may not sue the individual person. Some states still maintain some form of sovereign immunity, and the only action there is against the individual involved, the technician, the maintenance person, the engineer. They may face personal liability. You must check. You must find out where you fit in the state's program. So if you follow what we're talking about in the area of liability and risk minimization, you will also be minimizing your own personal risk. As you see, the courts tend to be sympathetic towards public employees who faithfully carry out the duties that have been posed upon them. In other words, as long as you have done a faithful, reasonable job, you will probably tend to do well in a court. It's when you abuse your power, it's when you act unreasonably, that you will face personal liability in those areas where you are not protected by statute. You must remember that your abuse of discretion occurs if you are designing things and you know that there is a safer design and you do not utilize that safer design. Then you can face liability personally. Even government officials have been held personally liable for neglecting their duty, as long as it's a negligent neglection. So you must remember, when you're doing your designs, when you're doing your reviews, if you know a safer way of doing it, do it. It's very important to your own liability and the liability of your agencies. State and local governments are only required by the law to exercise reasonable care to make and keep the roads in a reasonably safe condition for the reasonable, prudent driver. The reasonable, prudent driver is that driver who can function properly in every ordinary situation they are placed in. And as long as you are providing a reasonably safe area for the reasonably prudent driver, liability is reduced. The motorist has only the right to presume that the road is safe and usual and ordinary for reasonable traffic. They are not required to anticipate extraordinary danger or impediments or obstructions to which the motorist's attention has not been directed to. This is where the problem develops in a construction work zone. It is not usual, it is not ordinary, it is extraordinary. So almost anything that is done in a construction work zone is considered extraordinary, and if the driver is involved in an extraordinary situation, is injured or suffers a loss, then you have met several of the requirements of a negligence suit. The duty, the breach, the injury. All of these are the extraordinary situation. That's why it is very important for you to develop certain safeguards in construction work zones. And one of them is the operational review after installation. The courts say you may not develop an ostrich-like syndrome. You must go out and look and see what is there. You must look and see what can be done to improve the work zone. You must look and see what materials are available to make that work zone safe. You cannot stick your head in your sand and hope that the problem will go away, because it will not go away. You must perform this operational review after installation. Dealing with the manual and uniform traffic control devices and other standards, you must remember one thing, that there are many instances where conditions out in the street will alter the circumstances, and something more might be required than what the manual calls for. Again, you cannot substitute standards for good engineering judgment. And if you see that you can do more than the manual calls for, do it. If you have to deviate from the manual, document it. The important thing is, don't do the minimum. Do more than just the minimum. That's going to protect you and protect your agency. Another area that I want to briefly talk about is the notice of defect. We know we have a duty to maintain the roads in a reasonably safe condition. We have another duty if we are advised that there is a defect in the road system. And that is, you have the duty to remedy and the duty to warn the motorist. If you cannot remedy the defect in a reasonable, safe period of time, you must go out and warn the motorist commensurate with the danger involved. If the bridge is out, put a sign up that says the bridge is out. One state only put a sign out that said men was working, not that the bridge was out. That is not warning commensurate with the danger. The other problem you face with notice of defect is that you do not need actual notice of a defect. The courts will construct notice for you if you fail to find the problem within a reasonable, safe period of time. That is why I say you must have their operational review after installation. You must go out and look for those problems. If you don't go out and look for those problems, the courts will say you should have discovered it, you had notice, you did not remedy it, and you're going to be liable. Those are some of the keys in reducing your liability. Some other recommendations that I have to minimize your tort liability risk is to have a accident record system and an accident surveillance program. Many times the same type of accident occurs over and over again in a construction work zone. And because there is no acceptable record system, you don't realize that. And it may be nothing more than a chevron or a sign or a little pavement marking, a little tape put down in the pavement that would solve the problem. You have to observe the problem areas and report needed corrective action. You have to have open lines of communications to the public, whether they're letters, newspaper articles, telephone calls. Their problems are coming into you. If you know about it, you can take action. You should answer all complaints. You should document the facts and engineering decisions. They're going to be needed if you do get into court in showing the court that you have taken your remedial steps. You must look for high accident locations. Take positive action to reduce these accidents. You must improve the warning system to the public. You must have a continuing program for maintenance and safety improvement, particularly in a construction work zone. We say that signs should be checked on a regular basis, perhaps twice a year, for their reflectivity, to make sure they are not bent, damaged, obscured. A construction work zone requires almost a daily check because the construction work zone is a dynamic thing. It is changing daily. So you must go out there daily and make sure that the signs are proper, they're placed proper, the pavement marking is proper. You must strengthen your organizational communications to make sure this work is done. You have to look for long-range improvements as well as short-range improvements. We have found that public education is very important because many times we as traffic engineers forget that the public doesn't realize what we know. And we put up signs and pavement markings that we are totally familiar with because we're using that daily, and the public knows nothing about it because this is a new sign. They have never seen the sign. What does a chevron mean? What does a curve sign really mean? So you must develop programs that lets the public know what is happening, particularly again in a construction work zone. And you must publicize your department's activities in upgrading facilities and safety standards. Must warn you, the law says that we are servants of an agent, the agent being the public agency we work for. The courts say that when a servant has failed in his duty to his agent or employers, and the employer has to pay money out because of that failure, the agency can recover from the negligent employee. Now, I'll be honest with you, we have not seen that occur very often. In fact, I will go on and say that we have not seen that type of action taken by our employers. They tend to take a more positive action. They can demote us, transfer us from the position we have, and even some instances promote us to get us out of sensitive positions. But agencies do tend to take some sort of remedial action. In Florida, where I'm from, we have discovered that if an engineer has taken a bad step and has caused the employee some sort of loss, that maybe it would be better to take the engineer away from his desk job and have him go out and work on one of our construction road crews. I want to say to you all, remember, the construction work zone is an extremely hazardous and extraordinary situation. Go out there and check it regularly to make sure you are doing the best that can be done. Thank you.